A teenager who killed a 17-year-old girl in a UTV crash earlier this year has entered a guilty plea in a deal approved by the victim's family. His punishment includes that he can never get a driver's license, and he has to tell his story to others facing drunk driving charges. But what did he not receive? That's what we're going to take a look at, and what happened in this upscale community of Oregon. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Sauvie Island, Oregon is a small community outside of Portland. It's near the border with Washington. It's small, only around 1,000 people reportedly lived there during the 2000 census. In addition to beachfronts, the island has a lot of farmland, with farmers growing everything from strawberries and peaches to zucchini and pumpkins. It's a popular tourist destination, especially during the fall. This is when local farms offer things like hay rides and pumpkin picking and corn mazes. But the rural areas of Sauvie Island were the scene of something horrific back in May. Teenagers celebrating the end of finals were drinking on a large piece of property when a UTV driven by an apparently drunk 18-year-old flipped over, and that killed 17-year-old Ava Lee Cruz of Scappoose. It's a city adjacent to Sauvie Island. Okay, so to help me parse out what happened during this investigation, as well as how the DA's office arrived at this plea deal that they did, I want to welcome back on criminal defense attorney Eric Faddis. Eric, good to see you. Thanks for taking the time to come back here on Sidebar. So the suspect in this case, Aiden Hurd, who was allegedly drunk when he got behind the wheel of this Polaris UTV, had only been 18 for a week when this crash happened. He ended up facing multiple charges, DUI, manslaughter, and according to the district attorney's office, his age was a factor. It factored into their decision about the punishment that he'd receive if he agreed to enter a guilty plea. So how big of a difference does it make to be charged as an adult versus a juvenile in these type of cases?
Oh, it can make all the difference in the world, Jesse. It can make a difference with respect to sentencing. Typically, in most states, the sentencing scheme for juveniles is pretty limited. You can put them in the equivalent of a juvenile hall, an underage facility for a handful of years. But if you're on the adult side, that potential prison sentence is enlarged by years, if not decades. And so it makes a tremendous difference, and age is certainly a factor in this case.
So according to this affidavit of probable cause, it states, quote, on May 18th, 2025, just after midnight, MCSO received information that a vehicle flipped. Victim was not breathing, but attempting CPR. MCSO deputies arrived on scene in the area of 15003 Northwest Gillahan Road. It should be noted that this is a more rural area of Monoma County, and portions of this incident occurred on private property on a pasture. Deputy Timothy Dominic was one of the first people to arrive on scene and was flagged down by a number of high school-aged individuals. Deputy Dominic had to run on foot in order to get to the victim, AC. She was laying on her back, not breathing, unresponsive, and appeared to have a deep skull fracture to the left side of her head. AC did not survive her injuries and died on scene. And the county district attorney emphasized during a news conference that this was an unusual case for them, an alleged drunk driving crash on a piece of private property as opposed to, on public streets. I guess, Eric, the question is, how does that make a difference?
Sometimes there are laws that apply only to public areas as opposed to private areas. Those are often traffic laws. Usually for a traffic law and a citation to be issued, it has to occur on a public road. But there are exceptions to that. It's not as if a person can just commit any crimes they want because they're on private land. Here, it sounds like the prosecutors did not think that that was an overly important factor, although it is different in the sense that, this person wasn't on public roads. They weren't necessarily endangering other people, and so that could be a mitigating consideration that the prosecutors took into account.
Now, authorities, they rushed to this property, which, by the way, was reportedly owned by a local school board member. So we're going to get to that in just a minute. But as deputies tried to work out, what went on here? How did this happen? They got multiple stories from 18-year-old Hurd that we need to talk about. So the affidavit lays out what deputies learned. Quote, prior to driving around the property in the Polaris, a group of 16 to 18-year-old individuals were drinking alcohol in a barn to celebrate finishing finals. Hurd, along with AC and Brooklyn Johnson, then drove in the Polaris around the properties. Hurd was in the driver's seat, Johnson was in the middle seat, and AC was in the passenger seat. It does not appear seatbelts or helmets were worn. It was incredibly dark on the property with minimal lighting as well. It was described that three of them went around the property once, and during the second run through the properties, Hurd made an abrupt turn overturning the side-by-side. The roll bar then struck AC on her head, causing the likely skull fracture that killed her. It is unclear who, but the individuals in the area managed to roll the Polaris back on its wheels off AC. Johnson managed to escape and crawl through the back of the Polaris to get help. Efforts were made to save AC's life. Now, Eric, let's think about this for a second. The alcohol, the helmets, the lighting, why is that all important?
So it's critical for the potential charges here. My understanding is that the prosecution initially went forward on like a manslaughter charge. And usually the mind state needed to prove that is recklessness, which means a person knew there was a risk, disregarded it, took that risk anyway. Even if it wasn't reckless, it was still likely negligent, which means that they should have been more careful under the circumstances. Like you said, very lack of visibility. They're on roads that appear not to be paved. There are no seatbelts or helmets. There were no safety precautions taken for this dangerous activity. On top of that, you add the alcohol, and it's just a recipe for disaster, which is what we have here.
Now, obviously, this is a story that we wanted to bring to you, and the reason that we can do this, the reason we can cover things like this, is not only because of the amazing support that we get from all of you out there, but also from our incredible sponsor, Morgan & Morgan. This is America's largest injury law firm. This is a firm with over 1,000 attorneys. You know why they're so big? Because they win all the time. They have recovered over $25 billion for more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. Out in Pennsylvania, a client was awarded $26 million. That is 40 times the insurer's $650,000 offer. You have another client in Pennsylvania that received $29 million after being offered only $500,000. And even if you think your case isn't worth millions of dollars, why not just start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar by clicking the link below or scanning the QR code on screen. Is there any explanation from a defense attorney point of view? I mean, if this is true, no helmets, no seatbelts, lights out, drinking. I mean, how does a defense attorney work with that?
From the defense side, you got to look at what the mitigating considerations might be. This driver, the defendant, was 18 years old. He was a young man. Unfortunately, young people make stupid decisions sometimes. That doesn't necessarily mean it should ruin their lives. However, in this case, we're talking about a death. So that stupid decision had a very real consequence. On top of that, though, defense is going to look at a likely lack of criminal history and whether this person really presents a danger to the community going forward. You have this 18-year-old, likely no significant criminal history, a horrible event that took place, but is he going to be a danger over the next 5, 10, 20 years? Those are important considerations, too, that might bode in favor of the defendant.
Let's also talk about what Heard apparently had to say on the scene that night after he was read his Miranda rights. It says, quote, when first asked if he consumed alcohol, Heard initially denied drinking. When challenged about the fact that there was an odor of alcohol coming from his breath, he admitted to consuming only 1 beer earlier in the night. And the affidavit goes into the field sobriety tests that were done on the scene, noting that Heard did not perform well. Court document also indicates that Heard agreed to a blood draw so they could determine his blood alcohol content, and the document continues. At the end of the evaluation, Heard then admitted, after being confronted again, that he had 2 beers and a shot of vodka within the hour before the crash. When asked about his drinking habits, Heard mentioned he has consumed alcohol on several other occasions for special occasions like Halloween or finishing finals. Heard further confirmed he has driven this type of utility vehicle in the past. Now, Eric, that's bad. It's really, really bad. But I guess maybe, and I don't want to put words in anyone's mouth, is what he may be trying to suggest is, I drank before, I've driven this before, that didn't have an effect on what happened.
I suppose that might be the horse that he was trying to ride on this. However, it's certainly curious and actually rather common when you have an alcohol-related event to have the suspect say, "Oh no, I didn't have anything to drink. Oh well, yeah, I did have that 1 drink. Oh, now I remember, I had 2 drinks. Oh, 2 drinks plus a shot." That number keeps going up, and certainly an 18-year-old is not in control of their faculties to a sufficient degree, even if they've drank alcohol at some point in the past. drugs. Their body can't handle it the same way a 21 and up person can handle it. And so even though he has that past experience, is that mitigating or is that actually aggravating that he's been engaged in this kind of unlawful activity as a minor going forward? And lo and behold, we have this tragedy that he caused while engaging in that same activity.
And reportedly lying to police is never a good idea. So after his arrest in May, he was charged with manslaughter in the second degree, DUI, 2 counts of recklessly endangering another person. Were you surprised by ththose charges, Eric?
Not terribly surprised. One thing people need to keep in mind is that, especially when it comes to DUI, a lot of people think, it's that involves me in a truck on a highway drunk or something. That's not necessarily the case. In most states, when you're behind the wheel of something that is motorized, that in and of itself can qualify as drunk driving if you're intoxicated. So the fact that this was a side-by-side, a utility vehicle, that doesn't somehow immunize the defendant from a drunk driving charge. So not surprised that was brought, and not surprised that the reckless vehicular homicide charge was brought either. It looks like the defendant knew about a risk that could have occurred and took it anyway.
Now, Heard appeared in court on May 19th, entered a not guilty plea. Ava's parents spoke at the hearing, asking for mercy. According to KPTV, Brooke Cruz said, "We wish we were not writing these words and want you to know she was everything someone could hope for in a daughter, a truly beautiful soul. While our hearts are broken for our daughter, our hearts are also broken for Aiden and his family. We are pleading with this court not to ruin Aiden's life. He will suffer enough and it will not bring our daughter back. And in fact, it is not something she would have wanted and it would tarnish her memory." Now, Eric, that is a strength of a family that is pretty remarkable. But how much of a difference does it make legally what the victim's family wants in this?
What a selfless position for this family to take after they have lost their beloved daughter at the hands of someone else's negligence, to say, hey, I don't think you should go super hard on that guy either. It matters here, Jesse. It matters because the judge takes into consideration typically the victim's position on what the sentence should be, on whether the plea should even be accepted. Oftentimes the victim is objecting, saying, hey, this is too lenient. But here we have the family sort of coming to the table and saying, hey, this was a horrible nightmare that happened, but it was a mistake. It was an accident, and we don't need to put this kid in a box for the rest of his life. I imagine that influenced how these proceedings played out.
Now, I want to play you some things to get a better context of what happened here. So Deputy District Attorney Kenzie Ludwig explained this plea deal that Heard agreed to on October 8th. Let's take a listen.
He has agreed to plead guilty. It's extensive, so give me a moment. To criminally negligent homicide. So that is for Ava's death. He will do 60 months of formal probation. There are a number of other pretty strict factors that are laid out in the plea petition that are all part of public record. But I think the most important thing is that he is not permitted to have any consumption of any type of alcohol throughout the pendency of the probationary sentence. He's not permitted to drive, even on public and private land. And then in addition to that, he has been asked to give 400 hours of community service back to the community, and 200 hours of that will be promoting and contributing to his own community in honor of Ava. Additionally, he is going to also speak at victim impact statements as well about his experience in this particular instance, so that people who are going through the system who have somewhat similar experiences can understand firsthand what he also went through to hopefully make a difference.
Now, District Attorney Nathan Vasquez said during the news conference that this tragedy has affected so many people in this small community, and the hope is that the resolution of this case will offer a little bit of closure.
This is a very special person, and it's such a huge loss to our community. We've worked extremely hard to come to the resolution we did. This is obviously something we take extremely seriously, and in making these decisions and how we resolve these matters, it is how we do it is with the very careful input of the victim's family, and making sure that we are balancing both their wishes with community safety. And through it all, it is our enduring message that this office will always be guided by the idea that we will serve this community with compassionate accountability. And that's what exactly happened here in this matter.
So, according to the DA, Ava's family's wishes, that weighed heavily. That influenced the decision about what type of plea deal to offer Heard.
They have wanted some form of accountability, which Aiden has provided since the beginning, and he's expressed significant remorse. They were very active and vocal throughout the entire process in what they thought would be the best form of giving back to the community, as well as seeing justice in their eyes and also rehabilitating Aiden for the future.
In this case, I would say extremely early and very often, what we heard out of this young man was that he wanted to take accountability, that he was immediately taking steps to, to engage in things like treatment, and he was certainly working with the victim's family. He has never shied away from accountability in this and his responsibility for what happened, and those were big factors.
So all in all, in the end, Heard was sentenced to 5 years of probation, 400 hours of community service. He can't drink alcohol during his probation. He is banned from getting a driver's license for life. After hearing all that, Eric, and thinking about the conclusion, what's your thoughts?
I'm glad they have measures in place to proactively address the substance issues that may have given rise to this case. I'm a little surprised, Jesse, that there is no significant incarceration. Look, in Colorado, where I practice, if you get a DUI, even as a first offense, and there's an accident, even if nobody died, there's a chance you're going to jail. This gentleman was 18. He caused another death under extremely reckless circumstances. The fact that there is no punitive measure as part of the sentence is surprising to me.
And by the way, if he violates that, what happens? He goes to prison?
If he violates that, he'll be subject to the full weight, the full potential sentence of the crime to which he pled guilty, which I imagine carries several years in prison. So he is on kind of a short leash here. They're going to be monitoring him. They'll probably do monitored sobriety where he has to take tests to ensure that he is not ingesting any substances. And if he steps out of line or commits another crime or is charged with another crime, that could trigger probation revocation proceedings, and he could be looking at serious prison time.
Now, I want to talk about another aspect to this. So this crash caused a stir in the community for another reason. According to the Oregonian newspaper, the property where this crash happened, as I mentioned before, it is owned by a now former school board member. The Daily Mail reports that the $1.8 million property is owned by Branda Jurasek and her husband Matthew Deerdorf. Now, Jurasek served as vice chair for the school district. The probable cause affidavit in connection with it made it clear, quote, there was no adult supervision present or in the area where the death occurred. So a lot of people want to know why Jurasek or other adults haven't been charged in connection with the apparent partying and the underage drinking. In fact, hundreds of people have signed a petition that called for an investigation not only by law enforcement, but by the school board. Part of the petition reads, it is particularly egregious that Aiden Heard, a Scappoose High School student, faces legal consequences for the crash, while Branda Jurasek, an adult and school board member, appears to face none. And during Heard's arraignment, the Oregonian quoted Deputy District Attorney Ludwig as saying, there is some deep concerns that the location where this happened, these high schoolers do frequent the property and consume alcohol and ride these dangerous vehicles, and that this could have been a very preventable situation and that the warning signs were all there. However, when questioned about whether the property owners or anyone else aside from Heard can be held accountable criminally, the DA had this to say.
Well, I was ready for that question and waiting for it. I'll say this, there's the way that Oregon law is written, it doesn't match up very well when we talk about criminal law and how do we hold someone criminally liable for this type of behavior. And what it is, what we're kind of talking about here directly is that, a landowner or a homeowner that negligently allows young people to consume alcohol, and then you have such a horrific, tragic outcome. So the law doesn't really provide us with good avenues to go at that criminally. There are certainly some civil options out there. And I know that that's something that the family will consider and go forth on. I leave that completely to them. When it comes to the criminal component, we had limited, I would say, evidence that connected us directly back to the homeowners. Would we like that evidence? Absolutely. We certainly worked with investigators and the people that were willing to talk to us, and we looked for that and searched for that. We welcome that evidence. If that were to come to us in the investigation, we would certainly look at criminal charges, and if we were able to bring them, we would.
Let's start there. What do you think about the criminal charges, potential criminal charges?
Most states, and I believe Oregon has this, have what's called a charge like contributing to the delinquency of a minor.
Yeah.
And usually that can be intentional, but can also be negligent. It often arises in situations where minors are provided with alcohol, or there is some sort of unlawful influence by the adult that contributes to a minor committing a crime. So I'd imagine that those would be on the table. Certainly they need enough evidence to prove that. But you look at, a case like fentanyl distribution. It's not exactly analogous, but oftentimes the dealer can be charged criminally for a death if they have provided the substance that gave rise to the death. Does that same principle apply here? I think that those are very real questions. Sounds like the community still has some open questions about the responsibility of the parents and then the school board member in this case.
You think there's a civil case here?
Oh, 100%. Yeah, I think there is absolutely a wrongful death case here. It sounds like the parents have significant assets, and so those can potentially be attached through a civil course of action. And in looking at that, the parents have this nice house. They're prominent members of the community. They have these vehicles on the property. So certainly it could be a high-stakes civil case that we see next in this ongoing saga.
You know what's interesting about that? So Branda Jurasek resigned from the school board in August after what she called intense public pressure. In a statement accompanying her resignation, Jurasek wrote, "Some people have made serious accusations about our family in the days since Ava's death. We want our community to know that the claims are false. We did not provide alcohol to minors. We do not condone underage drinking, and we have never allowed it in our home. I understand that people are in pain and looking for answers, but this rush to judgment, fueled by social media and encouraged by people who don't know us, has created a firestorm that distracts from what really matters. I'm saddened by how quickly some in this town have turned on us, and I'm concerned that the attention now falling on the school board is interfering with its work. For that reason, I've decided to resign from the board effective immediately. I'm not stepping down because of the accusations. They're false. I'm resigning because the board needs space to focus on the students, staff, and families it serves. I don't want any presence to become a further source of division." Now, Eric, if that's true, you can understand that, right? You can understand why she's stepping down. It's bringing a lot of attention here. It may actually compromise the work that they're doing. The other side of it is, this is her side. We don't really know what happened here, but just your reaction to the resignation in that statement.
In looking at that statement, of course, if the parents had literally nothing to do with this, then they probably do not deserve some of this negative attention. That being said, parents can be negligent without having some knowing involvement in the criminal activity of these young people and teens. Even if they didn't know about the alcohol use going on, maybe they should have. Maybe they had a duty to at least provide some level of supervision, especially if there are minors involved, and not just let these 18-year-olds do whatever they want on their property. So I think that objection remains, even if the basis for the resignation is 100% true, that the parents had no involvement in the drinking activities.
And let me just take it away from the law for a second. Let me go back to the human aspect of this. Think about the loss here, the preventable loss, because according to Ava's family, this is a girl that wanted to attend the University of Oregon, study child psychology, had a whole future ahead of her. They've set up a scholarship in her honor. According to a site with scholarship information, each year a one-time scholarship will be awarded to a student who plans to attend a college or university, trade program, or community college. Students should have experience with and or desire to support the education, mental health, and development of youth. Ava planned to attend the University of Oregon and pursue a career supporting the positive mental health of kids, a cause that meant so much to her. And in the end, now there's just a memory. We won't know the work that she could have done. And that loss to her family, her friends, the community, that's where I think I don't want this to get lost in all of this, Eric, as we talk about the legal charges and responsibility. It's never going to be the same again.
It is just immeasurable. I've read reports from that contain statements from the victim's parents, and they are just devastated as to be expected. This is a young girl who died through no fault of her own. She was doing, what is probably most people would consider common activities among teens. Now, it got out of hand. It sounds like she wasn't the driver. She wasn't necessarily encouraging it to get out of hand, but it did. That being said, she is really the innocent victim in all of this, and that loss will never go away. This sentence will never bring her back.
Eric Faddis, thank you so much for taking the time. Good to see you.
Good to be with you.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.